Al-Fatiha. بسم الله الرحمن الرحيم. الحمد لله رب العالمين، وأفضل الصلاة وأتم التسليم وأكمل التحيات على سيد السادات سيدنا ونبينا محمد وعلى آله وصحبه وسلم تسليما كثيرا. Alhamdulillah, in our lessons on the Mukhtasar of Imam Quduri, we have reached the section on Iqala. And Iqala is a cancellation of a sale. Right? So it's not a refund policy, it is to cancel the sale itself. And we will see the rulings related to it. But there's a moral dimension to Iqala. Right? In that, so Iqala is cancelling a sale. Right? When we look at the definition of it, in itself, once a sale is made, the sale is binding, right? The sale is binding unless there is a khiyar in it. The khiyar can be an option of cancellation, can either be stipulated, like khiyar al-shart, for example, or it can arise. A khiyar can arise due to a contingency. What would be a contingency? Such as, what would be some of the contingencies that would cause an option of cancellation to arise? Khiyar al-aib, if there's a defect. What is a aib? Yeah. كل ما أوجب نقصان الثمن عند التجار. By thaman it means qima, right? Anything that diminishes the price according to the tujjar. Allahumma salli ala Sayyidina Muhammad. So that's an option of cancellation if there's a defect with the conditions. Or but if there's no stipulation and no contingency, nobody can unilaterally just cancel the contract. Because what is the ruling of a contract? If you buy this mic from me for $100, what's the ruling now of what happens to the mic? Yeah, it belongs to you. And $100 that you have belongs to me. Now for me then to unilaterally just demand the mic back, that is me. That is me violating your ownership without your approval. كل المسلم على المسلم حرام. Right? Everything of the Muslim is inviolable for the Muslim. دمه وماله وعرضه. Their life, their property, and their honor. So I have no right to do that. And we've looked at the many hadiths about that, right? So therefore, let's say you bought this mic. But now the Minister of Interior does not approve of it. That, we have many expenses coming up, this, that, the other. Why are you buying a mic? So you want to cancel. Now, can you demand that I cancel? No. Right? But this is where we have to keep in mind that there is the legal, the role of law is not the promotion of virtue. The role of law is to set limits and to clarify what is unclear. Right? But so fiqh is a subset of religious guidance. But on its own, fiqh just says, that's not your right. This is my right. It won't tell you what's better to do. Why? Because it is not where virtue is sought from. And that's why we've emphasized it's very important with one's study of fiqh to be aware of hadith. So we'll just cite 3 hadiths related to cancellation. or four, right? And they're similar. One of the hadiths is in the Sunan of Abi Dawood, right? From عن أبي هريرة رضي الله تعالى عنه أنه قال رسول الله صلى الله عليه وسلم من أقال مسلما أقال الله عثرته, right? من أقال مسلما أقال الله عثرته. It's rated by Abu Dawood and others, right? And the hadith is a Sahih hadith, right? Whoever cancels for a Muslim, Allah cancels their stumbles, right? Whoever cancels for another Muslim, Allah cancels their errors, right? Meaning, aqala Muslim, whoever cancels the contract another Muslim made with you, and a Muslim here is incidental, right? Right? Whoever cancels the sale of another of a Muslim, Allah will cancel their stumbles. Athra is their slips and errors. Khati'a and غفر الله زلته, Allah will forgive their stumbles and their errors. And in a hadith related by Ibn Majah, also from Abu Hurairah, it's come very similarly. من أقال مسلما أقاله الله عثرته يوم القيامة. That whoever cancels the sale of a Muslim, Allah will cancel for them their errors on the day of resurrection. And this emphasis is because, because Allah may overlook them. It could just be that Allah will bless you in your worldly life, and that if you're nice to people, they'll be nice to you. Like sometimes there's worldly benefits of our good conduct, but this hadith in Ibn Majah emphasizes that the benefit is in the next life, right? And in a hadith related in the Muwatta of Imam Malik, and we'll stick with those two. There's other hadiths about it as well, but these two should be sufficient, right? من أقال مسلما أقال الله عثرته in Abu Dawood, and similar wording in Ibn Majah with the mention of the day of resurrection, right? And you can find them quite easily. Okay, باب الإقالة. إقالة, the commentator says, هي لغة الرفع. يعني إقالة in the Arabic language means to lift something. And the lexical meaning here is significant because it results in اختلاف, in a difference between the Imam and the Sahibain. And we emphasize this, it's good for the diligent talib ilm to look at the lexical meanings of words, which is why having access to the various lexical dictionaries is very useful. And we've mentioned a few before, have I? The legal dictionaries. So, Tilbatu Talaba of a Nasafi, is an earlier Nasafi. And Al-Mughrib of Al-Muttarrizi, who's a student of the students of Az-Zamakhshari. Al-Mughrib with a dhamma on the meme. And there's also Anisul Fuqaha of Al-Kunawi. There's a book called Dusturul Ulama by one of the Indian scholars, 4 volumes. I always forget his name, but there's only one such book. So in the Arabic language, iqala is to lift something. Okay? وَشَرْعًا رَفْعُ الْعَقْدِ is to lift the contract. And this is very important. Why? Because is it a new agreement or is it just to lift the contract? Because if it's just lifting the contract, then in the iqala all you can do, there's a contract, you can lift it. That's it. So can you renegotiate terms out of iqala? That's what the issue comes up between the Imam and the Sahibain. So let's see what Imam Al-Quduri rahimahullah tells us. He says, Al-iqalatu jaizatun fil bay'. A cancellation is permitted in a sale. Right? It's permitted. Right? And بمثل الثمن الأول, with the like of the first price, meaning the agreed upon price at the sale. This according to Imam Abu Hanifa. Because all it is lifting the first contract. Right? And the iqala can be either with, it has an explicit ijab and qabul, or it can be bil fi'l. So I'm on the phone, Zayn comes with the thing, and he sort of goes like this, indicating the Minister of Interior, and he puts it on the table. I gave him $100. We wave. Halas, it's understood that he returned it. Right? So what if they want to negotiate it? He wants to cancel it. So he tells us, فَإِنْ شَرَطَ أَقَلَّ مِنْهُ أَوْ أَكْثَرَ فَالشَّرْطُ بَاطِلٌ. If one stipulates less than the first price or more than the first price, this condition is invalid. With that term, if you say إني أقلتك البيع, because iqala, because the lexical meanings are taken into consideration. Iqala just means رفع العقد. So the رفع العقد is according to what we agreed upon. Right? Which is why in the Tanweer it says, what is the iqala? He says it's فسخ في حق العاقدين فيما هو من موجبات العقد. Right? So the iqala is a fasakh. It is a cancellation of the contract and what is entailed by the contract with respect to the two transacting parties. There's a third element. What about a third party? But we'll leave third parties out for now. And in the Majalla, you can see this item 191 and 192. There's some talk about the iqala there. Okay. So if they stipulate that I'll cancel it for more or for less, this is not a valid condition. وَيُرَدُّ مِثْلَ الثَّمَنِ الْأَوَّلِ, and all that is due is the first price. Because let's say that Sidi Zain comes back and he doesn't want this for $100. Like he doesn't want it. I have two options, right? I can cancel the contract, and by definition, the cancellation would be I cancel the contract that was agreed upon. Or we make it into a new sale. I say, I'll buy it back from you for $88. Or let's say I sold it to him and I got in trouble because I was going to sell it to the sister, but we hadn't made a sale. So you come back and say, here's the money for the mic. I'd forgotten. I'd promised I'd sell her. There's no more of these. So what happens then? I could ask, say, can we cancel the sale? Say, no. I'd only cancel it for $120. Can we cancel it for $120? No. What would we have to do? No, because we cancel, khalas, it's mine. If we cancel, what happens? Yeah. We could say, I'll sell it back to you for $120. Right? That's all there is to it. So what is the iqala? هي فسخ في حق المتعاقدين. It's a cancellation with respect to the two transacting parties when possible. وبيع جديد في حق غيرهما. But it's considered like a new sale with respect to a third party. Right? And right? And this is في قول أبي حنيفة, right? And this is what was chosen by most of the mutun, right? When Imam Quduri mentions in his matan في قول أبي حنيفة or عند أبي حنيفة etc. It's pointing to the fact that there's اختلاف, right? Abu Yusuf was very practical. He considered a cancellation to be a sale. Simple as that. So you could cancel at whatever price, right? So there's some implications to these principles, but we'll keep out of them. Then he says, وَهَلَاكُ الثَّمَنْ لَا يَمْنَعُ صِحَّةَ الْإِقَالَةِ. If the price paid perishes, because the price could be money, but it could also be, the price could also be what? Could be an item, like in a exchange of goods. I'll buy this. Sidi Zain says, I'll buy this mic for this rare copy of this Sirah book by the great Azhari, the great Egyptian female scholar called Ma'al Mustafa. Right? So what was the item of sale? The mic. And B kada, this is the price. So this gets ruined, so it's not returnable. Then بمثل الثمن, right? So its material value would be due, right? Just as if we made the sale and what we agreed the price was perishes, the sale is valid because الثمن وسيلة والمبيع مقصود. Right? The price is a means to the sale, and the item of sale is the maqsood. It is what is sought from the sale, as we've taken. But وَهَلَاكُ الْمَبِيعِ يَمْنَعُ مِنْهَا. But if the mabi', if the item of sale perishes, it prevents cancellation. Because what are you going to cancel now? right? So let's say he bought the mic and he decided to start cycling. So he came to my store and said, you know that mic I got? I want to return it. And at that time, Zubair reversed his truck and crushed both your bike and the mic. Can we cancel the sale now? No, because the item of sale no longer exists. فإن هلك بعض المبيع, what if some of the item of sale perishes? Whether it is something like, let's say you bought 25 fountain pens from me. 5 of them are ruined, we can cancel in the 20. Right? So we can cancel in the rest of it بحصته من الثمن, by its share of the price. It could be this 20, multiple units of the same thing, or the mabi'a, the item of sale could be multiple items in one. So you bought a computer and a printer and an external keyboard and whatever, and the printer. Your best friend thought it was a fancy chair, so they sat on the printer and tried to make themselves comfortable, and the printer broke. You could cancel it and the rest of it, right? And he explains that. There are a number of extra issues related to iqala, but we'll stick to these today bi'idhnillahi ta'ala. The next section. So if someone wants to do it, so this, according to Imam Abu Hanifa, iqala is very straightforward, right? Iqala is a cancellation. Cancellations on the terms of the original contract, that's it. Any other stipulation would not be valid. But if you want to diagram the issues, they're explained by Imam Al-Maydani in the Lubab, that there's also the position of Imam Muhammad and the position of Imam Abu Yusuf, right? Abu Yusuf and Imam Muhammad, whose opinion is slightly different, but according to both those opinions, if a different price were set, it would be valid, right? So if it was the norm in a country, in a land, that people cancel at a discount or whatever, that would be allowed because there's a tertib. According to Imam Abu Yusuf, the default is that the iqala is a new sale. If it cannot be considered a new sale for certain reasons, then it would be considered a cancellation, right? And if it can't even be considered cancellation, then the iqala would be invalid. According to Muhammad ibn Hassan, it's considered a cancellation. If it can't be considered a cancellation, then it would be considered a sale. If it can't even be considered a sale, then it would be batil. You could diagram those three. So the case would be, if you try to refund it for $110, $100 mic that we sold for $110, you want to refund it for $100. It was sold for $100, you want to refund it for $110. According to Abu Yusuf, there's no issue in that anyways, because it's considered a new sale. And that can be acted upon when the custom is that. Simple thing to do practically is that if you want to cancel for more than the original price, just make it a new sale. Make it a buyback. I'll buy it back for whatever, less or more or whatever. Skirts the problem. Okay. باب المرابحة والتولية. So these are called buyu'ul amana, right? Trust sales. For two reasons. Or for multiple reasons, but two of them being, one is that the buyer is trusting the seller about how much he bought it for. Okay. And they're a trust on part of the buyer that he's being truthful about his original price. So why would the buyer want to do this? So that it would be, let's say, I decide to start shipping clothing from Turkey. Now I figured out the men's clothing market. Last day, there's a hijab merchant suggests that I buy hijabs from her. I don't know anything about the hijab market. The hijabs look good, but I don't know if this is a good price or not. So the hijab merchant wants me to buy it. So my interest is, I want to get a good price. The hijab merchant, the hijab wholesaler says, look, I will sell you these hijabs at my cost price plus 20%. That's murabaha. Tawliya, murabaha, and then what is tawliya? Anyone prepare? Yeah, tawliya is to sell an item at its cost price. Someone saying, look, I'm going out of business, I have all this stock, I'll sell it to you at cost. Now, in a murabaha, so there's an interest for the buyer, because if I don't know the industry, whatever, this gives me a sense that this is a good price. There's an interest for the seller, is that you're convincing the buyer that they're getting a good deal. But it revolves around trust. Practically, unless you know that the other person is trustworthy, it's better to avoid this. Why? Because the asl, while we hope that people are truthful, the basis of muamala is you view people as being upright and honest, but you act with caution. We flip the narrative, right? We have ill opinion of people, that they're corrupt and they're not upright in their dealings. But we deal with them without any caution. We just jump in, blind, both feet, and then we get into a mess. Nasallallahu alaihi. Rather, we have a good opinion of people, right? So, Sister Zubaydah wants to sell me these hijabs. I have a good opinion of her. I think she's inshallah, a good person, and I believe she's honest, but I exercise my caution. So unless I know her to be upright and trustworthy, I shouldn't get into a murabaha or tawliya agreement with her. So murabaha is a cost plus, right? Cost plus either agreed upon amount or cost plus percentage. Tawliya is at cost. And there's a third case which is called, what's the third case called? Does he mention it? Al-wadi'a, which is to sell below cost at an agreed upon discount, either unitary or percentage. I'll set this to you at cost minus 20%. I'm trying to clear my stock, let's say. So is that clear? So that's murabaha and tawliya. Now, it is murabaha when the cost is made part of the contract. So if it just comes up in negotiations, right? In discussions, I say, well, I got it for this much. And you say, no, really, this and that. We have just part of our general conversation. Then that's not. Just pass the chair for him. Then that's not considered to be murabaha, right? That if in our negotiations, I'm trying to sell you this mic. So I say, Shaykh Yusuf, man, please, this mic's a good deal. I got it for $95. I'm only making $5 on it. But then when we make the sale, I just say, I sell you this mic for $100. Is that murabaha? No. Because the cost, my cost, did we make it part of the contractual agreement? No. So this is something to be very clear. Murabaha is when you bring the original cost into the sale, right? بعتك يعني هذا الجهاز يعني ب100 على أنه قام علي ب$90, right? That I sell you this mic for $100. Given that, my cost for it was $90. So here I've incorporated the cost, either, right, explicitly, or given that I am making only 10% or 11% profit on it. So that's made part of the contract. So a friend of mine who has a book business, he'd buy and he's a book publisher, but also buy and sell books. A lot of books, I say, he'd be negotiating and say, but yeah, Shaykh, Wallah, he said, لا تذكر السعر. He said, do not mention the price. Right? So why? He says, I don't want to make a sale that's بيوع الأمانة, from the sales that are trust-based, if I don't know the person to be trustworthy. ولا أريد أن يقع غيري في الكذب. And I don't want the other person to fall into a lie. Even if it doesn't count as murabah and tawliya. Because I don't want to put my fellow Muslim in a situation where they lie. So let's just negotiate on the price. Don't tell me about your cost. Says خلينا رجال. Okay? In Jordan, they often say rijal with like sort of almost like a shadda on the jim. Rijal meaning like real men. Of course, it's not like fusha, just rijal, but right. And that's a beautiful consideration. That in negotiation, you don't want to put the other person in a situation where you get them to lie. That's why the Prophet ﷺ warned, "At-tujjar humul fujjar." Right? Traders are the most corrupt of people. Whereas it's also come from our beloved Messenger sallallahu alaihi wasallam that the tajir, as-sadiq or as-saduq al-amin, the trader who is very true and trustworthy, will be resurrected with the prophets and the martyrs and the righteous. And why? Because it's rare. Because in trade, people say things they don't mean, do things, and right? And the hadith, at-tujjar humul fujjar, right? It's in the Musnad of Imam Ahmad, and the hadith is sahih. Right? Right? And in one of the narrations, also in the Musnad of Imam Ahmad, the Prophet ﷺ said, "Inna tujara humul fujjar." Truly, the traders are the corrupt ones. The Sahaba said, "Ya Rasulullah, alaysa qad ahalla Allahu al-bay'?" Has Allah not deemed sales to be permitted or trade to be permitted? So the Prophet ﷺ said, Bala, indeed he has. لَكِنَّهُمْ يَحْلِفُونَ وَيَأْثَمُونَ. Because they swear oaths, meaning that they don't fulfill, and they fall into sins. They are two separate matters. Right? And in another narration, also in Imam Ahmad, that the Messenger of Allah ﷺ said, "Inna tujarahumul fujjar." So a man asked, "Ya Nabi Allah, O Prophet of Allah, alam yahill Allahu al-bay'? Has Allah not permitted trade?" Allah says it in the Quran, "Ahallallahu al-bay'." So he said, sallallahu alaihi wasallam, "Innahum yaquluna fayakdhibun." They say things, but they lie. وَيَحْلِفُونَ وَيَأْثَمُونَ. And they swear oaths and they commit sins. One by breaking oaths, or if they make too many oaths, and they commit sins, delaying prayer from its time, etc. Like lots of ghafla comes in to sales. Anyways, so the reason we're mentioning this is that this is a mawdi' ihtiyat. Now another thing is, in modern transactions, there is, so murabaha in classical legal usage is this kind of transaction that we will be describing in this chapter. In modern fiqh al-mu'amalat, there's a separate thing called bay'ul murabaha, right? A cost plus sale. But it's different. So murabaha, according to classical fuqaha, is that Zubair comes, he wants to buy this mic. So I want to buy a mic because Zubaydah and I are starting a podcast called Zuzu. Zubaydah, called Zuzu. Called Zuzu Talk. Okay, good for you. Says, I don't know anything about mics, but I want that one. Says, but Zubaydah said, don't pay too much for it. So how much did you buy it for? Right, so we agree. I bought it for 100, so I'm going to sell it to you for 110. So, but put that in the contract. So I sell you this mic for $110. Given that, or on condition that, I bought it for 100. Although it's better, as we'll see in the text, better to say, إِنَّهُ قَامَ عَلِيَّ, because that its cost for me was this much. Because there's some things you can add to the cost. إِنَّهُ قَامَ عَلِيَّ, because it's cost upon me, because there's certain things you can include in the price, in your cost, and the other things you can't. Okay, so that's classical murabaha, which you will see here. Murabaha in modern fiqh al-mu'amalat is typically used for a type of financing sale, which is, let's say that Sidi Zain found a whole bunch of young activists, all of whom want to start their podcasts. Right? So at the activism certificate, so all these young activists, they all want to start their podcasts. So he wants to buy 20 of these mics. But does he have money to buy 20 mics? So I said, okay. Said, he goes to Rabbani Electronics. Said, I'd like 20 of these mics. Oh my goodness, that's $2,000. I can't afford $2,000. But Farid, who's selling, who you're dealing with, said, sorry, said, can I pay it over a year? I need the money now. So bay' al-murabaha, so Farid says, I can't finance it for you. So a financing party comes. Sidi Hamza. He says, look, he sees an opportunity to make some money. Now, if he were engaged in ribawi financing, what would he do? He said, okay, the mics would be $2,000, right? So A ribawi financer would say, I'll sell it to you. Now, even like, I don't know why. I got socks from a particular company. I get 2 sets of emails from them several times a week. I don't know, maybe because I open the email every time. Twice a week, I get 2 different sets. I bought socks from them twice from 2 different emails. Now you can finance your socks. Like you can pay easy monthly installments. It is ridiculous. Like, how many socks does someone need? Anyways, so the financing party is okay. I'll finance this for you for 1 year at 10%. Let's say that's riba. So a ribawi agreement would be that you want to buy 10 mics is going to cost you $2,000. I'll sell it to you for the ribawi financing party RFP says, okay, we'll finance it to you for $2,000 plus 10% financing annually over this time. So you make this number of payments. That's riba. Right? So you bought something for 2,000, but you have to pay 2,000 plus Y within the contract. That Y is riba. But riba is within the contract, and that's coming up next. A murabaha sale, the financing party says, okay, you want to buy those mics? How long are you going to take to sell them, to pay for them? So if I could pay for them over 2 years, that would be ideal. Say, look, if you bought them now, it would cost you $2,000 up front. You want to finance it for over 2 years. You think, okay, how much do you want to profit from this? Because you're taking a risk. Right? Because you're going to... So what do? You say, I will buy the mics and I will sell them to you for $2,400. So what's the sale between Zain and HFP, Halal Financing Party? I sell you these mics for $2,400, payable over 2 years, be 24 payments for $100 a month. This procedure, but of course, for this to be permissible, there are some conditions. You need to actually, you can't just give him the money and him go buy it, because that would not fulfill the conditions. Can we share the Islamic finance and introduction? This Bay' al-Murabaha is explained by Mufti Taqi Usmani and the legal justification of it. So it looks a little bit like riba, but there are fundamental differences. This is the modern Murabaha. It's not ideal. It's not ideal because it's not that different from riba, but there is differences. Why? Because in the riba agreement, the sale takes place between buyer and seller. The financing party just provides the financing for the agreement. So Zain buys a mic from me for $2,000, the mics for $2,000, and he finances them through the financing party, for example, or from me. So you buy them for $2,000, and you're going to pay $2,000 plus interest. That plus X within the contract, that is riba. زيادة مشروطة في عقد معاوضة مال بمال مشروطة لأحد المتعاقدين. Riba is an increase that is stipulated in a contract of exchange between 2 transacting parties, stipulated for one of the 2 transacting parties. We will be coming to that definition. In a modern murabaha, I'm the selling party. The financing party buys the item of sale and resells it at a markup. And the basis is you can sell anything you want at any price you want. But the sale price is fixed. It is not connected with riba. You could end up paying more through this resale than you would through ribawi financing. right? Because really, you're making about almost 20% per year markup for this resale, whereas the markup for just riba financing was 10%. That's totally irrelevant. So here, so this is what's called murabaha in modern transactions, right? And inshallah, we should have a link to the Islamic Finance and Introduction book, because that's a very useful text by Mufti Taqi, and I'd encourage you to read from it. And it's widely available online, Islamic Finance and Introduction. Okay, so this is a distinction. Classical murabaha, right, we mentioned, sell you this mic for $100, $110, on condition that I bought it for $100. Tawliya, I'm selling you this mic for $100 on condition that it cost me $100. Wadi'a is, I'm selling you this mic for $90 on condition that it cost me $100, right? So, but we stipulated that within the contract in its meaning. Okay. Imam Al-Quduri says, Al-Murabahatu نقل ما ملكه بالعقد الأول بالثمن الأول مع زيادة ربح. Right? A markup sale is a sale in which one transfers what one owns through the first contract, which is your purchase contract, with the first price. Right? مع زيادة ربح, with a stipulated profit. So here where it says بالثمن الأول, the tanweer puts it in a more legal expression. Right? So he says, where it says بالثمن الأول, in the tanweer it says بما قام عليه وبفضل. Right? For what it cost you plus an increase. Right? وبفضل. Right? بما قام عليه, because we'll see what you can add to the original purchase price. Right? والتولية, and a at par sale, نقل ما ملكه بالعقد الأول بالثمن الأول. Right? Yani it's to transfer what one owned through the first contract, which is your purchase contract as a seller, for the first price. Right? So I bought it for 100, I sell it to you for 100. But again, the same thing applies. من غير زيادة ربح. Right? Without any profit. Why would you sell something at cost? To clear your inventory, for example. Or many other reasons. You want to establish a business relationship with somebody. So to establish the relationship, you incentivize it. I'll sell you these things at cost. Because once you establish a relationship, then you can convince them to buy other things after. Or whatever other reason. ولا تصح المرابحة ولا التولية حتى يكون العوض مما له مثل. Right? Both a cost plus sale or an at cost sale, the murabaha and the tawliya, are not valid unless the item of exchange be something that has a similar in the marketplace. Right? Because if it's a unique item, then there's no qima. There is no market price for it. Right? So can you do this for an item of, for example, what would be something that laysa lahu mithl? An artistic creation, a unique item of calligraphy. There's only one of it. There's no mithl for it. Right? Now, what could you add to your original cost? He says, وَيَجُوزُ أن يضيف إلى رأس المال أجرة القصار والصباغ qiraz, right? والفتل وأجرة حمل الطعام. It is permitted to add, meaning إلى رأس المال, to the original price, the cost of, what is the qassar? The Johra Neira explain what's the qassar? Okay. Yeah. Al-qas. Yeah. So al-qassar, right? The qassar is the one who readies the cloth, right? So it could be bleaching and other like things. So gets the cloth ready. The sabbagh is the one who dyes it. The tiraz is the putting the tiraz, the embroidery, right? Because sometimes that's a standard thing that for example, someone wants to buy a Moroccan thobe, so they got the cloth, but someone needs to before they put it up for sale, they do the basic embroidery. They would often embroider the buttons, right? For example, or the ends, right? So that's part of the cost of the thing, right? وَأُجْرَةَ حَمْلِ الطَّعَامِ, and likewise the cost of carrying the food, right? So you bought the food in the village, right? And you brought it to the market. The cost of bringing it to the market you could include in the cost of selling the food, right? Because the urf is, and this goes back to the urf, that the urf is that these are considered to be from the cost of the item, right? So this is why one looks at what is considered to be from the cost of the item, right? So there's basically two principles, and Al-Maydani mentioned there's two principles related to what you can add to the cost. Number one is ما كان في عادة تجار في من إلحاقه بالثمن. What is added to the cost price in the custom of other trade of the marketplace. By market practices, this is what you include in your cost. And number two, anything that adds to the value of the item of sale. Right? So you have rough cloth, right? The cloth is processed. So the processing adds value. The cloth is dyed. The dyeing adds value. The cloth is cut up. It adds to the value. The cloth is embroidered. It adds to the value. Right? But let's say you got a cow and you decide to sell it. Took you 6 weeks to sell the cow. You're feeding the cow. But does feeding the cow add to the value of the cow? No. Could you include that? You have to pay for storage because you couldn't, you decide to bring the cow home because you bought a cow, you decided to start business, you bought a cow home. Do you think your parents would let you bring a cow into your house? No. So you had to rent a place to keep the cow. Can you add that to the price of, like if you're going to sell it up, that I'm selling it at cost. So you add how much you bought it for, let's say $1,000 for the cow, plus $250 for someone's garage that you convince them, can I keep it in your garage? You can't add that to the price. Right? However, but if you add things to the original purchase cost, he says, ولكن يقول قام علي بكذا. Right? This is its cost for me. ولا يقول اشتريته بكذا. You don't say, I bought it for so and so, because that would be a lie, because you didn't buy it for so and so. Right? But, for example, if you bought a herd of sheep and you sell them, you cannot include the price of the shepherd or the rental. Kira is the rental of the Bayt al-Hifz, of a place where you guard the objects. It's, your storage cost. You can't add it to it. Right, so let's say you bought 2,000 copies of a book from South Africa. You realize the book industry is not for you. You want to sell them. But you held on to them for a year. You paid $2,000 for storage. So the book itself, 2,000 copies of a book, the cost price of the book was $10 each. The unit price per unit, you ended up paying $1 per book for the storage. Right? Can you say this book cost me $11? No. Right? You can't say I bought it for $11. That's a lie. Right? Say its cost for me is this much. Right? And my unit cost on the book is this much, which is the purchase price plus storage plus the things that you can customarily add to it. But that's where you're being trusted for that, right? You're being trusted for that. Now, the buyer may want evidence for that, right? Such as, contracts, invoices, etc. So you want to confirm, and that's between the two parties. I don't believe you. It's up for. Do I have to believe you? No. I may seek proof. Now, what happens if there's cheating? Right? فإن اطلع المشتري على خيانة في المرابحة فهو بالخيار عند أبي حنيفة إن شاء أخذه بجميع الثمن وإن شاء فسخ. Right? If the buyer finds out that there's cheating in the markup sale, cheating from whom? من البائع, from the seller. How? Either by the seller's admission or by clear proof. Right? So بإقرار, which is admission, or burhan, clear proof. Right? And clear proof is that which would be proof in court, not just I have clear proof. Right? And or number 3 is nukul, a refusal to swear an oath in court. Right? Or a refusal to swear an oath in court. فهو, then the buyer has the option. فهو بالخيار عند أبي حنيفة. He has a choice according to Abu Hanifa. If he إن شاء أخذه بجميع الثمن, he can take it as is for the agreed upon price. وإن شاء فسخ, or he can cancel. Because he did agree to that price. He did agree to that price. But he didn't agree, but his trust was betrayed. Right? That the seller said, I sell this to you for $120 on condition that I bought it for $100. Turns out he bought it for $75. According to Abu Hanifa, the buyer has the right to either take it for the agreed upon price or to cancel. Meaning that ولا حط عند الإمام فيها. According to Abu Hanifa, he cannot reduce the price by the extent of the cheating. وإن اطلع على خيانة في التولية أسقطها المشتري من الثمن. But if the buyer إن اطلع أي المشتري على خيانة, if the buyer finds out that there is cheating in the at par sale, then he can reduce the price by the extent of the cheating, right? According to Abu Hanifa. Because what was agreed upon, he'd agreed to buy it at cost. So I'll buy this mic from you for $100 on condition that its cost for you was $100. Turns out the cost was $95. There, it's my right, because I agreed to buy it from you at cost. So the cost is $95. It's your moral right, moral duty to reduce the price by $5. وقال Abu Yusuf يحط فيهما. According to Abu Yusuf, in both cases you can diminish the price. وقال Muhammad لا حط فيهما. You cannot diminish the price in either case. But in both cases, you have the right of cancellation. But the opinion of Imam Abu Hanifa is the relied upon opinion. Okay. So now he mentions a few issues related to different scenarios of transaction. Right? So, to understand this, we need to understand that there are two types of items of sale. Right? There's bay' al-manqul and bay' غير al-manqul. The al-manqul is something that is transferable. Right? You can literally, it means I can give it to you. Right? Right? So if I can give it to you, then what do I have to do? And this relates to a clear hadith of the Prophet sallallahu alaihi wasallam, right? ما لم يقبض. Right? That the Prophet sallallahu alaihi wasallam forbade selling something that you haven't taken possession of yet. Right? Right? And there's a number of hadiths about that, of prohibiting selling things that you haven't taken possession of yet. Why? Because if you haven't taken possession of it yet, قد يهلك, it could be destroyed and it would lead to dispute. Right? So let's say, and this of course is very important for online sales, because people are very lax about it. They do what's called drop shipping or whatever. Yeah. So they set up an online storefront. They sell a whole bunch of things. And once a sale is made, they go quickly and look to where they can buy it from. It's not permissible in that form. But it can be done correctly, that you can take it's like technically there's a pre-sale. Like you've taken an order. Like, and you see a lot of online stores do this. And this is, of course, on the part of students of knowledge and Shaykh types, you need to understand how transactions work, how the marketplace works. So what do they say? Many say, we have received your order. Technically, no sale has taken place yet, Islamically. So you ordered something from an online reseller. We have received your order. we are now processing your order. Sometimes they tell you, unfortunately, we couldn't find this, that, or the other. Happens sometimes. I've bought like a number of used books online from some online used bookseller. We have received your order. We're processing your order. We regret to inform you that this. So at some point, now the order, we have confirmed your order. It is shipping. Very often they'll do it at the point of shipping. This is your order. And you get billed then, or they'll bill you initially, and then they'll refund you the money. Why? Because if we said the sale is binding, what are you going to do? Where I sell you something, I don't have it yet, but then I can't find it. I sold you her cow, right? So she bought a cow. How much was it for? No, $1,000. I don't know what cow prices are. How much does a cow cost in Ontario? Could you check? Right? But let's say, I know she has a cow. Now, let's say, and it's an organic cow, been raised by a loving Mennonite family, and it was owned for a while by Sidi Fahim, and Sidi Fahim's daughters recited Quran in the presence of the cow. So it's like a blessed cow, like it's just waiting to be slaughtered and eaten by righteous people. So you wanted to buy an organic cow that'll give you milk. You want organic cow milk. So I know she has a cow, right? Can I sell it to you? So I say, okay, I'm going to buy it from her. So what do? What's the Surah Al-Masala? I'll buy the cow from you. So I buy the cow from you for $1,200. Do you agree? Right? So there's a sale. Now I bought it from her. I said, okay, I have a cow. So I put you on, I put you on hold, bought the cow. I said, okay, I have a really good cow. I send you pictures of the cow, and there's a resume of the cow's life. Do you agree to buy this cow for $1,500? Say yes. There's no cow. There's no sale. Don't mumble. Yes. Okay. You agree to buy the cow. What's the problem? I own it. Because when this sale took place, I own the cow. What's the problem? I haven't taken possession of it, actually or effectively. So what happens? I go to pick up the cow ran away. Because she forgot to pay for the storage, or she did pay for the storage, but it's in someone's garage. The kids were looking for their basketball. They opened the garage door. Cow ran away. Now what do we do? Because it could lead to dispute. Firstly, she'll say, I own the cow. It's not her responsibility. You want a cow. I don't have a cow. Right? So this would lead to, and practically, because the Prophet ﷺ forbade, نهى رسول الله صلى الله عليه وسلم عن بيع ما لم يقبض. And there's hadiths for it. النهي عن بيع الطعام قبل ما لم يقبض. Allah. Okay, so he tells us rahimahullah ta'ala, وَمَنْ اشْتَرَى شَيْئًا مِمَّا يُنْقَلُ وَيُحَوَّلْ لَمْ يَجُزْ لَهُ بَيْعُهُ حَتَّى يَقْبِضَهُ. Whoever buys something that is transferable and is movable, it is not permitted for them to sell it until they take possession of it. So the buyer cannot sell the item that they purchase until they have taken possession of it. Qabd. And the qabd can be haqiqi, can be physical possession. So I went, took the cow itself. Right? But I don't want to, what am I going to do with the cow? I don't want to take the cow. So what do I say? I find somebody who lives in that neighborhood. Say, okay, look, I have appointed Shaykh Zahir as my agent, old friend, he owes me a few favors. Technically, he does. I should call him for a few favors. To schedule a few favors for 2020 from Shaykh Lahir. Give me some ideas. So I said, Shaykh Lahir, could you do me a small favor? Say, yeah. So are you going to be out and about tonight? Say, yeah. Say, can you go and take ownership? Can you be my agent to take ownership of this cow that I bought? I said, sure. So Shaykh Lahir, who has a few cows in his backyard, let's say, takes ownership of it on my behalf. The qabd can be haqiqi, where I take it myself, or hukmi, which is the qabd, the haqiqi, or the qabd of my agent, my wakil. Or it can also be qabd hukmi, and the qabd al-hukmi is برفع الموانع بين, right, when the risk of the item is transferred to me, right? And so that would be with, so in person, for example, let's say I sell. You have a fountain pen. Is that a fountain pen? Let's say, do you have a fountain pen? No. So you want to buy my fountain pen, right? So let's make a sale. I sell you this fountain pen for $20. I won't hold you to this. Just a Surat al-Aqd. It's a decent price. I think you could buy it for 23 online. But yes? Okay. So you bought it. Say, here you go. Now, is there anything preventing you from taking it? So if I place it in, this is برفع الموانع, by lifting any impediment between you and taking it. This is called qabd hukman. So we make the sale, then we go home, right? Next day, a very, Omar and Ustada, they're cleaning up. They say, what's this shiny object, whatever, they're like, maybe some kids thing. They put it in lost and found. And then we can't find the pen. The ownership has transferred to you. Why? Because there's qabd hukman. I left it in a place, there's nothing preventing you from taking it. But I say, okay, it's yours now. And I put it in my jacket. So you can take it whenever you want. But was there qabd hukman? No, because normally, would someone go and grab it from inside my jacket? No. Okay. But how can I give you a plot of land? So Sister Zubaydah, Zubayr died of a heart attack from Zubaydah's food. So what happens? She inherits $1 million plot of land. She sells it to Sidi Hamza. Now Sidi Hamza, can the plot of land be delivered to you physically? No. Right? Because it's not a physically transferable item. It's not manqul. Right? Now, a plot of land, in normal circumstances, assuming there'll be no like earthquakes or khasf or land just collapsing, does anything ever happen to the land itself? In the general condition, land doesn't run away, land doesn't die, land doesn't perish, land doesn't get used up. Right? So يجوز بيع العقار قبل القبض. It is permitted to sell aqar, fixed property, right? Before taking possession of it, عند أبي حنيفة وأبي يوسف. They put a condition on this, which is العقار الذي لا يخشى هلاكه, of that which there's no impending fear of it perishing. Why? Because let's say, it happened in Pakistan. Look at it. There's some islands that appeared off the coast of Balochistan a few years ago. They actually grew to a certain size. And then they've disappeared. So I don't know the fiqh of what it would have been to sell them or not. But let's say something like that, where there's reasonable market fear. That if you ask 10 experts in selling offshore islands, that is this going to perish or not? But by default, you can sell property, like fixed asset, fixed property, like land, a building, before taking possession of it, because nothing's likely to happen to it. Okay. This is according to Abu Hanifa and Muhammad. Abu Yusuf said it's not permitted unless one takes possession of it, like by the keys being given to you, etc. Because he said the hadith is general. The Prophet ﷺ forbade selling that which is one hasn't taken possession of. But Abu Hanifa said no, because it's because of the fear of halak, of its perishing. So if someone wanted to be cautious, they wouldn't sell like land without taking possession of it, to avoid the difference of opinion of Imam Muhammad. So this is something that now in contemporary issues it's discussed, like what is effective taking of possession, because online, with high volume sales of commodities and so on, people buy on the spot. They buy and sell within seconds of each other. Forget seconds, milliseconds. Often there's automatic buying and selling, right, of commodities and so on. So this becomes a big issue. We can't get into all the details, but effective taking of possession of something is defined as, and is discussed in Mufti Taqi's Islamic Finance and Introduction. And it wouldn't hurt any of you to just read the whole book and summarize it, because it's an excellent introduction to some of the underlying principles related to Islamic finance. It will help you understand the classical text as well, but also many of a core of the modern issues from the greatest living authority on the subject. So basically, there's effective ownership of something when the rights and responsibilities of the item now accrue to you customarily, right? And but when you buy something on, like things like drop sales and so on, or drop shipment, etc., like you set up an online storefront where you take orders and then you go look for it online and then you resell it. You make the sale in stages. You take the order, your order has been received. You could even take the money then, but that money would be an amana. And you cannot use that money until... So the right way of setting up, you take the order, they make the payment, you can take the payment. But that money you should not use until you've confirmed the order and now you're ready to to ship it, for example, or to deliver it. Then you finalize the sale. The sale has now been confirmed. And there's some fiqh related to it. And later on, when we look at the fiqh al-mu'amalat in more details, we'll look at some of those points. Bi-idhnillah. Okay. ومن اشترى مكيلا مكايلة أو موزونا موازنة فاكتاله أو وزنه ثم باعه مكايلة أو موازنة لم يجوز للمشتري منه أن يبيعه ولا أن يأكله حتى يعيد الكيل والوزن. So whoever buys something on condition that it is a certain volume, right? Kail is selling something by volume, like liters is volume. Whoever buys something sold by volume, a bishartil kail. This is really important, right? Meaning bishartil kail. أو موزونا موازنة, or something sold by weight. And the commentator mentions, أي بشرط الكيل والوزن, meaning on condition of its weight or volume. It is, and then it's weighed or measured, right? It is not permitted, and then he sells it. It is not permitted, and then he sells it by weight or volume. It is not permitted for the new buyer, for the second buyer, to resell it without having weighed it or measured it. Why? Out of the possibility that there could be difference which would lead to dispute. So what's the surah al-mas'ala? Let's say the sister sold the cow for $1,000. So she decided now to invest in high grade basmati rice. A lot of basmati rice that's sold is poor quality. So good, there's characteristics of good basmati rice. One that's actually from India or Pakistan, because there's things from the US and stuff called Texmati, etc. It's not actual basmati. There's real basmati rice, and some things that pass as basmati rice from India are not actually basmati. There's lower grades, and there's basmati that's cheaper quality. But proper basmati has been stored, has been aged for a period of time, because it gives it more fullness of color and taste. And anyway, so she gets high quality, organic, aged basmati rice. Okay. Now, so she buys a container of basmati rice. Now, if she just says, there's a container, says, I'll buy this container of basmati rice for $1,000. And the description of the container is that this container has 1,000 kilos of rice. Are you buying there on condition that it's 1,000 kilos? No. The 1,000 kilos there is just a wasf. It's a descriptor. For example, when you buy a bag of apples, what does it, and it says on it 5 kilos. What are you buying? You're buying a bag of apples with a description, a wasf, that it is 5 kilos. That's not the issue here. When you buy a bag of coffee and it says 12 ounces, what is the 12 ounces there? It's just a wasf, it's a description. If it's less or not, if it's less, you have an option of cancellation. That's a separate matter. But I bought a bag of coffee and I'm selling you a bag of coffee. The description is 12. That's a separate issue. Here, it's when the weight is a condition. The sister says, because hard-earned money is more harder than she expected to store that cow. Took 3 weeks to sell it. She still made a couple $100 on it. So she's keeping the profit and reinvesting the $1,000 originally. So she bought premium basmati rice. So what does she do? She says, I'm buying this container of rice on condition that it is 1,000 kilos. So when you receive it, firstly, it's your moral duty, either at the time of contract for it to be weighed in your presence, or as soon as you receive it, before doing anything else, before beginning to use it, before starting to sell it, it is your moral duty to ensure that it was in fact 1,000 kilos. Why? Because let's say you start selling it off, the 1,000 kilos, start selling it off in bags of 10 kilos. You get to bag 95, you realize, oh my goodness, it wasn't 1,000 kilos. Now will you be able, it'll lead to dispute. The person is like, what can I do for you now? You've sold most of it. Right? And people make mistakes in this in a lot of things, especially wholesalers and stuff. Right? And there's a bigger principle, right? That when the measure of something is important, count it before you transact in it. You got 100 copies of a book. Count them before you start reselling the book. Because after the fact, it'll lead to dispute. It's not morally permitted. And there's issues related to this mentioned in the books of Hadr al-Ibaha. Similarly, the same concept applies to other amanas. Let's say Sheikh Yusuf is traveling to South America and I owe somebody money there. So I owe them $2,000. So I give him a sealed envelope that this is $2,000 for so-and-so. So he just takes a sealed envelope, gives it to so-and-so. He counts it, it's 1,800. Properly speak, if it's an amana, either give the amana as is. I'll take it as is. But it say here, if it's an amount to give to someone, then you should count it. And according to some of the fuqaha, a lot of the fuqaha, it's wajib to count it. It leads to dispute. It leads to mistrust. Because when it gets there, he says it's 1,800. It's a molder of tuhma. Then what happened to the $200? It's probably my fault. But there's 3 unsatisfied parties. I'll be wondering, what did you do? You'll feel wronged, and the person who received money feels someone owes him money. Right? So that's why this is a wider issue. That anything where you're trusting an amount, before you act upon it, count it. Payments as well. This is $3,000 for this. You should count it right there. Otherwise, you go home and then you count it, and maybe you dropped it in the car, etc. These things lead to dispute. But once you bought something, so once you bought the rice on condition that it's 1,000 kilos, you need to weigh it. But when you sell it to Sidi Hamza, then what happens? You cannot, when you buy it, you need to weigh it again. Right? ثم باعه. Even if she weighed it, you weighed it, it's 1,000 kilos. You sold the whole thing to him, you need to weigh it again. Why? Because there's a possibility that you didn't weigh it correctly. You're just getting the hang of big business or small scale business. Or maybe your mother saw that there's loads of rice in the garage. She went, took some to make biryani. So it is less than 1,000 kilos. So it would not be permitted for you now to sell it until you weigh it again, or if it's weighed in your presence at the time of contract. Right? Lihtiyah, because the possibility of it having become less or becoming more. Right? And it has multiple harms. Now, we're not allowed to sell the item of sale before qabd. But he tells us, وَالتَّصَرُّفُ فِي الثَّمَنِ قَبْلَ الْقَبْضِ جَائِزٌ. Dealing in the thaman, right? In the sale price before taking possession of it is permitted. Why? Because what would the case be? I sell you this mic for $100. You have no other money, let's say. That $100, you could lend it to someone else. Right? Because the prohibition relates to the mabir, the item of sale. Also because الثمن لا يتعين بالتعيين. The price is not specified even if you specify it. So these are sort of add-on issues related to sales. Then what does he say? ويجوز للمشتري أن يزيد البائع في الثمن ويجوز للبائع أن يزيد في المبيع. It is permitted for the buyer to increase the price for the seller. And of course, the condition is that the ba'i', the seller, accept. And it's permitted for the seller to increase in the item of sale if the buyer agrees. Why? There's a good spiritual reason for it, which is that the best of you are those who are best in fulfilling their terms. And one of them is to give more than what is due. Right? It's give more than is due. It's good. And worldly terms, it's good business. But in itself, for this to be considered part of the transaction, there has to be an actual or effective agreement. Because I don't want to discount, right? Because the businesswoman here, is already giving me a hard time. First with the cow, then with the rice. Now you're selling me mics. So I'm doing you a special favor. I'm going to give you a $20 discount. I don't want your discount, right? Because then she's going to give me a hard time about it for the next 2 years. And I'm stuck having to deal with her. Because she's the only supplier of certain types of products. Right? So I don't want a discount. Right? So this is if there's agreement. ويجوز أن يحط من الثمن. It's permitted likewise to reduce the price. ويتعلق الاستحقاق بجميع ذلك. And the rights related to the contract relate to all the above. Right? So basically, العقد يتعدل بالتعديل. A contract can be amended by the two parties, amending it. Right? So, like we agreed to something, so that the rice you bought, when you're selling it, initially you decide to sell it for $1,000 for the. But then you Googled how much does good quality 1 year age basmati rice go for? You realize $1,500. Oh, I could probably have sold it for more. And if it's organic, it's $1,700. So you go to Sidi Hamza and say, Sidi Hamza, I think I sold it for too little. And you show him the reasons. Sidi Hamza is an upright trader. He says, that's fair. I'll pay you the market price. So I'll increase the price to $1,500. Say, no. Let's do $1,400. So the original sale was $1,000 for the 1,000 kilos of basmati. You amended it to you offered $1,500. He offered $1,500. He said, no, I'll accept $1,400. Once you agree to the amendment, the contract becomes amended, and whatever is due to this, right, would go back to all of this, right? So الزيادة والنقص في المبيع أو الثمن يلتحق بأصل العقد, right? An increase or decrease in the price or the item of sale is considered an amendment of the original contract. Okay, another issue that he mentions, وَمَنْ بَاعَ بِثَمَنٍ حَالٍ. Whoever makes a sale with a price due upfront. ثُمَّ أَجَّلَهُ. Then they defer it. أَجَلًا مَعْلُومًا. With a known deferral. صَارَ مُؤَجَّلًا. Then the price becomes deferred. What's the surah al-mas'ala? I sell you forget the mic. The sister sold 1,000 kilos of basmati for $1,500. So Hamza thought that's a good price. But then he checks his pockets. He doesn't really have $1,500 due up front. He says, that's going to be tough to pay all at once, because I also need to buy books. He said, okay. you could pay it to me in 3 months. Say, great. Can we make it in 3 monthly payments? Even better. Right? So you can, just as you can adjust the item of sale, the price, you can also adjust the terms of the sale, such as the deferral period. وكل دين حال إذا أجله صاحبه صار مؤجلا. Any debt that is due immediately, if the person who's owed the money agrees to its deferral, it becomes deferred. How? In a sale, for example. The money was due now. So, okay, let's agree on terms. You can pay it to me over 6 months. And this, of course, really, it's a praiseworthy matter, right? The Inzarul Mu'sir, giving time for the one in financial difficulty, right? من يسر على معسر يسر الله عليه في الدنيا والآخرة. Whoever grants facilitation, said the Prophet ﷺ, to one in financial difficulty, Allah will grant them facilitation in this life and the next. So someone owes you 6 months of rent. They say, you need to pay me 6 months of rent. Say, well, things are tight, this and that. And they're being, so you say, okay. It's recommended, it's not obligatory for you. But you say, okay, let's agree on repayment. The rent you owe, pay it back over 6 months. Person says, they agree. This is permissible. And if it's done out of the person being in difficulty or hardship, there's tremendous reward in it. Right? إلا القرض, except for a loan. فإن تأجيله لا يصح, because specifying a deferral for a debt is not permitted. And this is, so this is the asl of the madhab, right? A qard, right? A qard which is a loan. A qard is frequently referred to as a qard hasan, a good loan. Why? Because there's 2 types of transactions. There's uqud al-muawada. There's contracts of exchange where both parties are giving something of material consideration. Right? Such as sales or hire, sales or lease or hire. There's either an item of sale or a benefit, the use of this house, the renting of this car, the use of this car for a period of time, the employment services of a person, right? And the other person gives the payment, sale price, rent price, lease price, hire, whatever it is, right? So these are contracts of exchange. It's called uqud al-muawada. But then there's uqud al-tabarru', right? There's contracts which are one-sided. When I lend you something, a lending is a contract, because I am giving you this pen. Are you giving me anything for it? No. Now, it could be i'ara, lending. I give you this to use. So i'ara is one example of aqd tabarru. I just gave you I granted you the right to use it. I'ara, lending. Or hiba, I gifted it to you. If I gifted to you, what did you give me back? Nothing. Tabarru. Or, so these are 2 examples, right? I'ara, I lend it to you. I can take it back at any time. A qard, what is the agreement? A loan, let's say Zubaydah, now the sister becomes a huge industrialist. You've done all kinds of different financial transactions. You made lots of money. So you want to empower other sisters. So Zubaydah comes, I want to start a business. I'll lend you some money. Go and start your podcast. Right? Zubaydah thinks she's going to make a lot of money on her podcast. Because Zubaydah and Zubair recorded 20 episodes. They've been fighting in every episode. They expect that it'll be very interesting for people to listen to their halal fights. So anyways, so if you lend $100,000, now, is this what kind of contract is this? Right? Initially, it's like i'ara. You're lending the money. Right? Right? So, as Imam Alam al-Maydani says, لأنه إعارة وصلة في الابتداء. Initially, it's like lending and just lending and giving. صلة يعني تبرع وعطاء. You're just freely giving something to the other party. That's in the beginning. But that's in the beginning. When you give the money, you're just lending the person the money. But at the end, it's muawada. It's an exchange. Because when the person is giving the money back, what money are they giving back? What you gave originally. So in terms of the beginning, in a tabarru', in something in a lending, I've given you my property. Right? Like if I lent you this pen for a week, if I came tomorrow and said, can you please give me my pen back? Now, if you rented it for a week, can I take it back? No. But if I lent it to you, even if we put it in writing, I lend you my pen for 1 week, 2 hours later, if I said, give me back my pen, is that 1 week binding on me? Is it? No. Because there's no consideration from your side. It's just tabarru', I willfully let you use it. So in a qard, in a loan, this is the theory. We'll look at the practice in a second. In a loan, insofar as the beginning, which is you're just giving your money to somebody else, it's i'ara. I have just given it to you for no consideration. Because Islamically, you cannot charge more than a loan has to be at par. So in that sense, you cannot, the deferral period is non-binding. وَمُعَاوَضَةٌ فِي الْإِنْتِهَاء, and it's a contract of exchange insofar as the ending. Right? In the ending, at the end of it, it's $100 for $100. And so that there's the meaning of riba there. And when you are exchanging like items, you cannot stipulate deferral, as we will see in the chapter of riba. So how can you do deferral of loans? That's why fiqh is different from fatwa. This is the theory. The theory in our madhab is that in loans there cannot be a binding period of deferral because it resembles the meaning of riba, even at par. For the reasons explained briefly. right? And we'll look at the reasoning that what happens with riba, right, which is the next section. So, what happens then? How do we validate this? One is to have two agreements. If you want to do it according to the madhab itself, you can have a contract, a loan contract, and a repayment promise. You have two contracts. يعني عقد اقتراض, a loan contract, and you just mentioned this is the loan, and a التزام بالتأجيل, a commitment to defer. And that would be considered like a binding promise. Now, the problem with promises is that promises only work with trustworthy people. And of the signs of the end of the later days, right, is تقل الأمانة, that trustworthiness diminishes. So much so that people begin pointing out that in such town there's a trustworthy person. It becomes surprising that there be a trustworthy person. So what do you do? Because in itself, so this is not directly prohibited, but there is a related meaning that would entail prohibition or similitude to what is prohibited. There's a shubhat riba. There's a similitude to riba in it. It's not outright riba because you lent $100 on condition that you get repaid $100 in 1 year's time. On the relied upon position on the madhab, you cannot do that. Because the shubha of riba, because of the ta'jeel. So one way to do it is by aqd plus wa'd bil ajal. The contemporary fuqaha took an opinion from the Maliki school that, and some other fuqaha, that the specifying a deferral period for this is permissible. Right? Why? Because of widespread need. The other way that it works within the Hanafi madhab is say that the ajal, the deferral, is a condition in the contract. And the governing principle about conditions is that conditions are permitted if they're customarily made and they don't directly go against something in the Sharia. Right? So, because validating conditions is a significant matter. So, the fatwa would be that you can specify conditions because of umum al-balwa, because widespread problem of people not being trustworthy, right? If there's no deferral, then it would lead to harms on people. And people would not be repaid, etc. And it's also, there's the customary practice of people, right? And even more than that, because the custom of people is to transact on the basis of riba. You want to take them away from outright riba to agree to loans without riba. But they will not agree to loans without riba and without repayment period. So how do you validate that? Once to look at this is a shart muta'araf. وَالْأَصْلُ رِعَايَةُ الْعُرْفِ مَا أَمْكَنَ. And the basis is that we try to validate custom where possible. والله سبحانه وتعالى أعلم هو حسبنا ونعم الوكيل وصلى الله على سيدنا ونبينا محمد وعلى آله وصحبه وسلم. Next chapter we're going to be looking at one of the most central issues related to fiqh of transactions, which is باب الربا. نعوذ بالله سبحانه وتعالى منه ونسأله سبحانه وتعالى أن يباعدنا تمام البعد عنه. وصلى الله على سيدنا ونبينا محمد وآله وصحبه وسلم والحمد لله رب العالمين.